Here I am. This time I've escaped the stacks of Lincoln's Inn to come outside, so I'm in the garden at Lincoln's Inn instead. And this time I thought I'd speak to you about a subject matter case. And this subject matter case is London wine. This is important because, of course, it relates to proprietary interests in an unascertained bulk. So to what extent is subject matter certain in the bulk of wine or not? Hello. So as you can see, I've moved inside from Lincoln's Inn Gardens, and I've got a visual aid to demonstrate the next case that I want to talk to you about. And that's, of course, London wine. The citation is 1986 square brackets, PCC, page 121. And PCC is Palmer's Company Cases. So this is an interesting case for both trusts and the law of insolvency. That's because the facts of the case relate to a battle for value between, on the one hand, a receiver who was attempting to argue that the goods that the company had fell under his control, versus prepaying customers who were trying to assert that the goods in question were imbued with a form of trust that meant that they had an interest that usurped that of the receiver. Well, what were the goods? Well, as you can see, and as perhaps the name of the case suggests, the goods were wine. So it's a very interesting case for us. Here's some wine here in relation to subject matter, because, of course, what we might think at first blush in relation to tangible property. So here it is, actual wine, tangible, we can touch it. We'll perhaps drink it as well if we want to. We know, or we might think, that it's similar. So here we've got lots of bottles that are the same kind of wine over here. We might think that all of this wine, of course, tastes the same, and pretty much it probably does, unless one of these bottles is corked. Let's hope they're not, but one of them could be. If it is, let's say it's this one here, it would mean then, therefore, that this bottle is completely different to this bottle here at the front. Because, of course, it's corked, this one. It would taste awful, where this one might taste nice. So, whilst prima facie we might think that the subject matter of this case is relatively certain in the sense of innate quality, it in itself, even though described as exactly the same wine on the bottle, might be innately different because of corking, for example. That's the first thing to note about the case. The second is this. It's interesting in terms of the facts, because each customer, when they bought an interest in this stock of wine, so a particular vintage of wine, which was kept by the company in their warehouse, the London Wine Company, it would be laid down in that warehouse, and the customers, the prepaying purchasers of this wine, would be issued with a certificate of title that corresponded with the wine that they purchased. So maybe it could be the same kind of wine that we've got here, by way of example. So they'd have a certain amount of, pursuant to this title document, bottles of a given vintage. And it was through the use of those documents that the customers attempted to assert that there was some form of interest that they could look to that was trust-like in nature, and that document spoke to that interest. The receiver, on the other hand, of course, is trying to argue no, that the wine doesn't fall under that trust, isn't hoiked out of the value of the company, and instead stays within the assets of the company and therefore are susceptible to his use. Ergo, the value goes to his appointing charge holder, so the bank. So essentially here, the battle for value is between a bank as a fixed charge holder, or floating charge holder, I should say, in the guise of the receiver versus those customers. So eventually it goes up to Mr. Justice Oliver, who hears the case, and he says, or held I should say, that it could not be said that legal title to the wine had passed to individual customers, and that the description of the wine did not adequately link it with any given consignment in the warehouse. So legal title in the wine hadn't passed, and then there was an inability to sufficiently recognise from those title documents I've just referred to how that wine links, or may link, to the given customer and the specific bottles of wine that they thought were theirs. In other words, there was uncertainty of subject matter in relation to how that wine would sit with each given customer. So the receiver won in relation to the facts as argued in this case anyway. Interestingly, as Parker and Mellows, a secondary source that you're familiar with, have pointed out, now the Sale of Goods Amendment Act 1995 may be adduced by those customers to mean that the purchasers were tenants in common of the general mass of stock. So in terms of outcome, in this case, there's that solution, perhaps Sale of Goods Amendment Act 1995 solution as proffered by Parker and Mellows anyway. And the other solution, of course, is that if they can't assert that interest pursuant to a trust, that those customers would rank as unsecured creditors in any future liquidation, so that they'd have that potential bite at the cherry. The second of those solutions, of course, is not as attractive as the kind of trust that we saw was operative in cases like re Cayford or re Quisclose. So that's re London Wine. Do have a look at that case and see what you think, and mull on it in the sense of subject matter, certainty, tangible property, perhaps whilst enjoying a glass of wine. Until the next video, goodbye.